environmental. Ah, yes, we should have announced that. Sorry that there is recording. I'll just go back here uh, to Paul's biography.
Oh,
Sorry, what was that?
whatever it was an error, so just continue.
Okay. Um, Prior to his appointment, Paul was an adjunct professor at the University of Toronto and a member of both the Immigration and Refugee Board of Canada and the Environmental Protection Tribunal of Canada. He was also worked as an executive director of the Canadian Environmental Law Association, the vice chair of the Environmental Review Tribunal, and associate chair of the Assessment Review Board. So he brings decades of legal experience to his work as an integrity commissioner. So we have three very experienced panelists to talk to us. I'm going to give a very quick overview of the ethics system, such as it is. Um, I'd like to just briefly describe the purpose of ethics law regulation, um, give some sense of the historical change, although that could be a very long discussion, and I don't want it to be too long. A framework of the legislation and some of the institutions which deal with ethics, and some notion of current problems or perceived problems. The first thing I'd say, just very quickly, is that public service matters. Just that stark statement. Public service matters. Public service requires putting service ahead of self, respecting uh, respecting others and respecting the institutions of democracy, operating with integrity, that is, with honesty, probity, and uprightness, is a necessary component of a genuine, efficient, and fair democracy. So, ethics regulation goes a long way back. I mean, the criminal code contains corruption sections, and it was first established in 1892. Indeed, the Baldwin Act of 1849 uh, embodied senses of civic humanism and a sense of public duty. Um, but I won't dwell too much or take too much time on that. Conflict of interest was the main ethics regulation at the municipal level for decades, for 100 years. The first Municipal Conflict of Interest Act was in 1872. Sorry, 1972. The modern Municipal Act was enacted in 1983. There was an act entitled the Local Government Disclosure of Interest Act in 1994, which was enacted by the NDP government and repealed by the Conservative government. I mention it only because it included a commissioner, but that was never proclaimed. Um, the City of Toronto Act in 2006 introduced mandatory integrity commissioner and a code for the city. The Municipal Act was given an optional commissioner and code system. And finally, there were two amendments, one in 2017, which required codes and integrity commissioners for all municipalities. And then in 2019, a role was given to the integrity commissions in the Municipal Conflict of Interest Act. Some 25 years after the local Disclosure of Interest Act anticipated that. I'll just say briefly on the historical front, there have been three commissions of inquiry into ethics matters, which all of which have had effect on the system. The Bellamy inquiry is probably the most well known. It concluded, its report was in 2005. And then the Cunningham inquiry in 2011 and regarding conflict of interest of the mayor of the city of Mississauga, and the Morocco industry looking at the town of Collingwood's uh, code and so on. So we have three pieces: the criminal code, the Municipal Conflict of Interest Act, and the Municipal Act. The code deals with corruption and municipal corruption, which include breach of trust and fraud. The Municipal Conflict of Interest Act deals with pecuniary or monetary conflicts of interest. In the public sector, a conflict of interest occurs when a public duty clashes with a private interest. In the Municipal Act, there is a requirement for codes of conduct for council members and local boards, and the City of Toronto Act has similar provisions. The codes deal with various behaviors: inappropriate use of office, receipt of gifts, harassment of others, and so on. In terms of personnel, the criminal code involves the courts and police for enforcement. The Municipal Conflict of Interest Act relies on the courts and those who would bring allegations of conflict of interest to the court. Local integrity commissioners have a role to play now in this process. And then finally, codes of conduct rely on integrity commissioners who are appointed by municipal councils. Integrity commissioners have a complex role. They're advisors, educators, and investigators. In most local systems in Ontario's councils, at least ostensibly enforce the codes after receiving reports from commissioners. So there's some general issues. There's a complication or a complexity of having a bifurcated system um, between the two provincial statutes. There's a lack of enhanced protection for commissioners and their independence. There's a need for enhancement of budgets so they can actually do their work. So those are a few general issues. There are a number of issues which were raised during the discussion of the Municipal Accountability Act, and I imagine we'll get more into those. The alleged need for a standardized code for all municipality, the alleged need for standardized training of commissioners, as well as a perceived need for supervision in some way of commissioners, the need to make breach of codes a disqualifying event, and the desire to involve the Provincial Integrity Commissioner in all of this. And that's where I shall stop and ask Suzanne to speak.
Thanks a lot, Greg. Good afternoon, everyone. I'm happy to be here to participate on this panel with Paul Muldoon and John Mascarin. And I thank the York Collegium for Public Ethics for the invitation and for organizing this event. So I'll get right into it. I'm going to start off with a quote from, I love using this in any presentations I have. It's a 2018 book. Some of you might know it. It's called Municipal Ethics Regime, second edition. It's authored by Greg Levine. And in particular, the section that talks about why ethics regimes matter. I'm going to quote from what Greg says. From time to time, politicians and administrators bemoan the fact that an ethics system has been placed upon them as though acting ethically and fairly were undue burdens upon political activity and public administration. He says this is unfortunate because ultimately it's being ethical and being seen to be such that government administration gains respect. Greg goes on to write, democracy in general, local democracy in particular, is based on fundamental notions of respect and equality. In turn, these concepts imply positive ethical conduct by those who govern and those who administer the will of the governors. And then this last piece, I will say, I love the most. Greg says, dishonest, self-aggrandizing, self-fulfilling use of public goods, the public purse, and the public's trust demean government and administration and render it ineffectual. Accountability officers represent a powerful way to facilitate accountability in action at the local level of government, right where it matters, right where it often touches all of us, to address wrongdoing and ethical lapses of ethical and elected appointed officials in a nimble way. But the real report card happens every 4 years. It's the public who decides if they've done a good job. But in the interim, elected officials are overseen by integrity commissioners. The genesis of municipal accountability, Greg gave us an insight, and we see that in 2006, there was the reason for codes of conduct. But it seems as though we may have moved away from this. The regime was intended to allow councils to self-govern through the investigation and findings of an arm's length subject matter expert integrity commissioners. However, members of council have been reticent of late to fulfill this role, pushing back on this model. Members don't want to make decisions to hold their council colleagues accountable for their wrongdoing. And as a result, we find ourselves at a time where the intent of the amendments to the Municipal Act, set out in Part 5.1 of the Municipal Act, seem unappetizing to elected officials when it comes to holding themselves accountable and not following rules. As we are seeing more and more these days everywhere, not just in Ontario at the municipal level, those who cause the problems call out those tasked with addressing the problems and claim we are the problem. Under the current regime, municipal integrity commissioners are tasked with a unique and interesting fact-finding role. And Ontarians expect that city council members will meet very high standards of conduct, fulfilling their role, and that means serving the public interest, acting with integrity and competence, and avoiding conflicts of interest, avoiding improper use of influence. So ICs in Ontario do a lot of things, but where does this municipal code of conduct and the current integrity commissioner role come from? And does Bill 9 address a failing? My colleagues will take a deeper dive into exploring this question and talk about how Bill 9 will aid or derail the accountability tools currently in place. But I'll just mention from the Bellamy recommendation to the Mississauga inquiry to the Collingwood inquiry, municipal governments have been seeking to hold elected officials accountable for their actions. They're not employees of municipalities, and contrary to what some elected officials reply in their replies to code complaints, they are not just private citizens giving their opinions and giving voice to the grievances of the people. They are elected officials representing collectively the electorate, and since 2006, municipalities have been wrestling with deciphering this ambit of responsibility of these undefined agents, these councillors who don't have a definition in statute, whose only statutory authority is as the collective body of council. We've looked and heard about the Bellamy inquiry, and just very, very briefly, Madam Justice Bellamy set out in her report that an integrity commissioner can help ensure consistency in applying the ethical rules. She continued and stated an integrity commissioner provides significant profile to ethical issues and a commitment to ethical governance. She goes on to say, no matter how comprehensive the rules, there will on occasion be a need for clear guidance from an individual, and it was intended that that individual would be an independent, arm's length ethics advisor and integrity commissioner. And finally, Justice Bellamy stated, and Justice Morocco reiterated, that without enforcement, the rules are only guidelines. The rules must have teeth. Nowhere has there been a greater need for sharp teeth in ethical compliance than in situations where harassment and discrimination are carried out by powerful politicians against the administration of the municipality, who are caught in this power imbalance. However, there is reticence to bring forward such complaints because of the risk of losing one's job, the embarrassment of being put forward as having been the victim of sexual harassment. And so we ask ourselves, is the Code of Conduct regime an effective tool to address these serious instances of ethical errors? Addressing harassment conduct by elected officials seems to be one of the drivers behind the push for the enactment of Bill 9. There are usually rules in codes of conduct that prohibit bullying, incivility, lack of decorum, but also requiring members to treat one another without intimidation. And oftentimes, members of council who are subject of these code complaints believe that they are being alleged to have harassed individuals, but rather the code is silencing them from representing their constituents. The code prevents them from exercising their freedom of expression. The code is a weapon used to politicize disagreement with issues of note. Over the last few years, we've had the rise of what I call code of conduct martyrs, wearing as a badge of honor the penalties they have received, claiming on social media only having received these for freely expressing their opinions, the voice of the people, and bucking the powerful status quo. This political dance is moving us towards what is seen as not a divisive society, but rather codes of conduct that are ineffective. So I'm going to pass the baton at this point to my colleagues for them to take a deeper dive into some of the questions we're going to be talking about today.
So, Suzanne, I
Awesome,
think
John.
I'm up next.
Yes, thanks, John.
Thank you. Thanks, Greg. Thank you as well, Greg, Ian, and everyone at the Collegium for York for public ethics. I'm pleased to be here. It was such an August panel. I'm thrilled to be here with Paul and Suzanne. I will make some brief comments as well. I totally agree with what Suzanne has already said, so I hope I'm not going to be repeating too much. I do want to just focus just a little bit on what I think is one of the fatal flaws of the current underlying premise for what the municipal accountability system was put in place to do. And I think the lot of disrespect and just casting aside of the current system, I think relies back to a fatal flaw that was made early on, which maybe even the legislatures did not envisage would happen given the current climate that we see. And Suzanne has already spoken about the political divisiveness, the rancor, the rise of populism, and it's just something a little bit different than what was thought of when the Bellamy inquiry initially came forward and said, "Hey, the city of Toronto needs this, needs an accountability officer, code of conduct for staff and members of council, and an integrity commissioner to look after both." It didn't quite work out that way, but it worked out somewhat that way. So now we've got, and Greg has brought forward, I think the reason why this was put in place was we have the Municipal Accountability Act 2005, almost ready to spring forward at the provincial legislature. My respectful view is that Bill 9 proposes to strengthen municipal accountability in name only. It misses the mark in a number of significant ways. And I'll start with a quote as well. The current system has been pejoratively referred to as, quote, a fragmented system of accountability for local elected officials. Who said that? The Minister of Municipal Affairs and Housing. Totally ignores the historical reasons for the implementation of the original system in the City of Toronto Act, and then shortly thereafter by the Bill 130 amendments in the Municipal Act. And the rejection of the overarching provincial commissioner system that Greg mentioned that had been proposed and was actually put in place because royal assent was given to the Local Government Disclosure Act 1994, but then it was taken away. If you look at one of the very last provisions of the Municipal Act, when it was enacted in force on January 1st, 2003, Section 484 finally repealed the Local Government Disclosure Act. So let me just start with this. Is the current municipal accountability system not working? In many ways, I believe that the current system is actually working very well. Municipalities have the ability to select well-qualified, knowledgeable integrity commissioners. My two panelists have been chosen, in my view, wisely by both of their municipalities. They're well-qualified, experienced, knowledgeable, ethical people with integrity that are great to bring forward and put in place a system to govern local accountability. They are also there. Municipalities can craft today their own local codes of conduct that will be responsive to local needs and distinctiveness, something that I think the province is about to do away with. However, let me say this. Many municipalities have simply not chosen wisely for their integrity commissioners. Some have selected integrity commissioners that really are not qualified, are not experienced, knowledgeable, and articulate in the ways of local government. Okay. Some members also of councils do not appreciate that the integrity commissioner is actually entrusted to do a real job. and to do it independently. So here's where I come to. The fatal flaw, in my personal perspective, to the entire accountability system is that proper municipal accountability is premised on a largely false premise itself, that a locally elected council will hold its own house in order. That's what Suzanne Craig also mentioned. So recall that when the municipal accountability framework was first put in place, following the Bellamy inquiry that Greg mentioned, it was to make sure that a municipality would hold itself to account. The notion is that councils would be responsible for ensuring that their own members would be held accountable for their misconduct, misbehavior. The whole purpose of the City of Toronto Act, Part 5, and then the new Part 5.1 in the Municipal Act was implemented to counterbalance the new greater autonomy, authority, and powers that the municipalities were first given through the Municipal Act 2001 that had overturned 150 years of older prescriptive, narrowly circumscribed municipal acts. So municipalities are going to be given more power. So, in the words of Peter Parker, with great power come great responsibilities. This is the underlying notion. And we would all say, I think all of us here today would say, that should be the case. But that's not actually what's been followed. My observation is that what appears to have been a clear underpinning and foundation to the accountability framework here in Ontario, that councillors would be enforcers, has proven almost entirely incorrect for many of the reasons that Suzanne just stated. And in my view, and I've stated this many times to my own peril, that councils have actually become enablers of bad behavior. They look the other way. They decide to be lenient. They decide to be forgiving. They side with political allies. They worry about reprisals, and they're concerned that one day the shoe may be on the other foot, and maybe they'll be held accountable, and they don't want that. So my view, though, and I'm going to stop right here and I'll let Paul move on, but my view is that I'm very upset by what Bill 9 has provided. The province had a great opportunity to actually strengthen municipal accountability. And in what I have perceived in Bill 9, and I said this to the standing committee, in fact, Paul and I presented on the same day. I presented on the same panel as Jeff Abrams from Principles Integrity. I stated it is a performative statute. It's only for the show. It doesn't actually strengthen municipal accountability in any way. And that really disappoints me. Thank you, Greg, and thank you, the Collegium. I'll pass it on to Paul.
Great, Paul.
Thank you again for the invitation. And I'm the new one on the block. My first year anniversary as Integrity Commissioner for the City of Toronto just approaching. And both John and Suzanne have much more experience in the field. So I'll do what most Torontonians do. I'll give a Toronto-centric view of the world. And I think that's part of my role. And I do want to do it. The Bellamy Commission has been referenced a few times, and that dealt with computer leasing. And the commission found there was corruption, like clear corruption without any ethical framework to rely upon. So that created my office. And my office is unique in the sense that I'm appointed for a 5-year non-renewable term. It takes 2/3 majority of council to remove me. And I have independence in so many ways. And and I've got colleagues, the ombudsman, I've got the lobbyist registrar, and the auditor general. So the accountability officers as a whole, and we stand in a unique position. My role is to be the guardian of the code of conduct. And I will get to the notion of, does it work? But I want to just highlight that I've got two major roles. One is to investigate complaints about violations of the code of conduct. My jurisdiction extends not only to the 24 councillors and mayor, but to all of the 85 business improvement areas and all of the adjudicative boards, committee of adjustment, all of those municipal planning boards, and to even things like local arenas run by the city. So the jurisdiction in my office extends to well over 1,000 persons. And my job is to ensure that the applicable code of conduct is abided by. But my real role, I think, is that every day we get requests for advice on ethical issues. So my office drops everything and responds within 48 hours to those advice requests as what's going on. In other words, is that if I do a good job in giving advice on those issues, I don't have to investigate because it avoids the complaints. And just for those that aren't familiar, once my office issues a letter of advice, the politician, the council member, the mayor, the local board member is protected by that advice. So if I'm wrong, I wear it, not that member. So they don't come to me because they like me. They come to me because they need me. Now, our code of conduct was born from a very nasty scandal, but I agree with the kind of environment we now live in that both John and Suzanne referred to. And that environment is a polarized society. I can tell you that every day there's a headline. Anytime a politician takes a firm stand on any issue, I get inquiries on the other side saying they're wrong and we must start an investigation because how can that politician say such a thing? And that really puts one of the core challenges we have is trying to reconcile the freedom of speech of an elected member or a local board member versus the constraints upon that free speech guaranteed by the charter, by the applicable code of conduct. Where is that compromised? At what point can a politician take a stand, say something, but on the other hand, still be in compliance with the code of conduct? And the other issue is, which I think pervades in so many sectors, is just the irreverence to the penalties. We don't have a lot of sanctions. What we can do is, for at least what I can do for elected officials, is recommend to council there's a reprimand and a reduction in pay of some sort for a certain amount of time if council agrees to it. And so it stays in council's hands, and that then relates all the problems that John talked about is council's behavior. But the point is that at this point is that there's an assumption within this whole regime that a recommendation of a reprimand based on a factual evidence report means something. And that's an assumption that may or may not be still valid. What I want to do is spend a few minutes on Bill 9. And I say that because I think it impacts all of the integrity commissioners in Ontario, but it particularly impacts Toronto for a number of reasons. And I want to remind people that in September 2024, former provincial integrity commissioner David Wake issued a report about the problems, issues, and challenges of integrity commissioners. And supposedly Bill 9 was based in part on that report. And Bill 9 is before the legislature, and it's scheduled to be passed before the end of the year. Much of Bill 9 is not reflected, much of the report from Commissioner Wake is not reflected in Bill 9. So it's a missed opportunity at best that the issues that he brought to light, and he didn't particularly craft exact words, but here's the issues that should be addressed, are not reflected in Bill 9. Bill 9 does two things. One is that it creates a process to remove a councillor if there's a problem. I'll get to that. To me, the most problematic aspect is that it removes the inability of any municipality to create a code of conduct and then imposes a provincial code of conduct. For me, that's a problem, and I'll tell you why. The Toronto Municipal Council has evolved its code of conduct over 20 years. This is the 21st anniversary. The last review was in 2022. During that time, it debated, it had all kind of deep discussion, but at the end of the day, it accepted that code of conduct. They own it. So the first time in 20 years, since the inception of this office, since the Bellamy Commission, they'll have a code of conduct imposed from above. And I assure you that affects the psyche of each member, because no longer is it something they own, they evolve, they understand, they have a role in. Now it's going to be imposed. We have no consultation as to what that will look like, and we have no idea of the nuances that our code of conduct now has. Our code of conduct is incredibly detailed in certain areas, dealing with gifts, dealing with conflict of interest. In 2022, we added language where the conflict doesn't have to be a direct conflict, it can be an appearance of conflict. We added language that dealing with decorum, derogatory language, all kind of stuff. But all of it was based on 20 years experience, input of counselors, and debate. So that's going to be an issue. How can one code of conduct be applicable to 444 municipalities? The code of conduct for the City of Toronto, with the same code of conduct for Elliott Lake, Thunder Bay, Timmins, Barrie. I'm interested to see how that's going to work. So that is one of the key issues I have, and then we have to then try to find a way to ensure that all those subject to the code of conduct understand the differences and what the new obligations are. The second part of Bill 9 really deals with removing the counselor, and that requires that the Integrity Commissioner of the municipality recommend removal to the Provincial Integrity Commissioner. The Provincial Integrity Commissioner then reviews that report, and if accepts the report, then goes to City Council. And that City Council has to be unanimous. And I think, like most municipalities, very few times will the City Council be unanimous on any issue. Very challenging. What's interesting, most important, and we thought was a drafting error, was that if City Council decides not to remove the councillor, in other words, there's one vote saying no, there's no penalty. The issue is over. So we don't understand that, but the committee did consider that and voted for that. So at the end, I just want to say, is there a role for attendant commissioners? Yes. Does it prevent conduct that would otherwise be a problem? Absolutely yes. And what challenges me personally and professionally is, why is there an effort to erode it? And I point to Alberta. Alberta has Bill 50 that, like Bill 9, it removes the ability of municipalities to create a code of conduct and will impose not a provincial code of conduct, but replaces replaces municipal code of conducts with quote unquote meeting procedures and behavioral guidelines that will be overseen by the province. So while John and Suzanne and I agree that the world's getting more complicated, more polarized, more diverse, more irreverent, the trend legislatively is actually to reduce the guardrails to protect from that. And it is that irony that I lose sleep about. And in fact, we should be strengthening the ethics regime, not loosening it. So I'll leave it at that, but that's what keeps me awake at night.
Well, thanks very much. Thank you all. Actually, it was wonderful talks. I wonder at this point if each of you would like to respond or ask a question of each other before we go on to more general Q&A.
I'd like to ask a question, Greg. I wonder if I could pose maybe to both of you, but I'd start off with posing it to John. What is your strongest pet peeve right now as Integrity Commissioner? And as part of that question, do you see Bill 9 as proposed as an aid or a hindrance to addressing that pet peeve?
Thanks, Suzanne. Yeah, I have a number of pet peeves to be clear about the municipal accountability framework as it's working. But my one big one, and more recently, is this. It is, as you know, as almost every code I see has an absolute prohibition against a member of council receiving any kind of gift or benefit that relates to their duties or to their office. Okay, and then there's a carve out from that, and that's specific because you state the principle broadly. Because why are you in public office? Is it to get tickets to a Leaf game? You know, to benefit your friends? Quoting now, I think, or alluding to things that are in the newspaper or the media these days. No, you're there to serve the public. So the outright prohibition against receiving a gift or benefit is justified, and it's usually written in absolute terms, with then a number of carve-outs, because of course it wouldn't make sense to have that absolute prohibition and then not allow a member of council or a member of a local board to receive a stipend or an honorarium or some compensation for the public service that they provide. So that's just one of them. So that's all fine. What I found recently, and Paul and Suzanne, I'd love to hear if you have this experience. You have a matter. It doesn't look maybe that complicated. You are considering it. You feel that you need to put it in front of the council member just to get their views on it, to get some perspective for you. You write to them. You expect maybe a simple response. What do you get? I've retained a lawyer. And by the way, here's my lawyer's letter, and it's 20 pages long. Now, I know in Vaughan and in Toronto, there is some remuneration or some reimbursement that's permitted to members of council if they are to retain an outside lawyer. In many municipalities, this is not the case. But you're met with all of a sudden a letter, 14 pages, 12 pages, and it goes into Charter of Rights, it goes into procedural fairness, it goes into every possible thing that you could want. I need full disclosure and discovery of everything that's in your file, right? And I wonder, who's paying for this? Typically, it's not the council member, let me tell you. And I know, Suzanne, you and I have had this conversation, and I've had this conversation with many others. And it's a problem because it's a gift or benefit that's being hidden, and that's inappropriate. Paul, I think in the city of Toronto, I think one of the first integrity commissioners actually has some advice to all members of council on a member not being able to access free legal advice to act against the city. And yet, I see this all the time. I know Principles Integrity just wrote a report in Pickering with Lisa Robinson about crowdsourcing. I recall several years ago, Michael Maynard and I had a very similar issue down in Niagara region where we were very concerned about some GoFundMe pages or things like that. Completely wrong, very, very hard to get to. And what I ask is, you have an integrity commissioner who's neutral, impartial, objective, and not politically motivated. Why do you even need a lawyer on the other side? All we're doing is doing an investigation to understand. Now, again, I realize Vaughan and Toronto have this permission in there. I find that always quite curious because I always say to people, look, you have to comply with it. You can't obstruct. You should cooperate with us. And then you're sort of met with the complete opposite. And my always worry is, are they receiving a gift or benefit that they're not entitled to? We recently wrote a report on a matter that was quite controversial. It was an anti-trans meme that was sent out. We had to consider all sorts of charter issues, and we were met by a lawyer from the Democracy Fund, an entity that on its website says we pay for free legal services. This was during our investigation. We pointed that out, and we were met with, you're stopping me from getting legal counsel. And our answer was, no, we're not. but you can't receive free legal advice from the Democracy Fund, a crowdsourcing, or from your brother-in-law. I mean, if a candidate runs for election and they get legal advice, they're supposed to include it on their disclosure statement for expenses. So that's my pet peeve, Suzanne. Thank you for asking.
Um, Great, thanks, John. Other
Yeah,
remarks?
I'll respond to, first of all, to what John said. I think John's point is excellent. And again, from a Toronto perspective, I inherited a procedure where once we get a complaint, we look at the jurisdictional view to see if there's sufficient jurisdiction and see whether or not there's sufficient evidence in the complaint to launch an investigation. And then we launch an investigation formally because of all the rules of natural justice and procedural fairness. And that's when often lawyers get involved. That's when it gets formal because I've got all the powers in the Public Inquiries Act. What I found surprising, and this is Toronto-centric, I believe other jurisdictions are maybe different. There is this time between I get the complaint and I launch an investigation. I like to talk to people. And in other words, there's no mediative process where you can sit with the affected parties and talk it out. Often you may get a different perspective. Often there may be an apology coming. Often you can see this misunderstanding of what happened. But I don't want to have to go through a full investigation, then dismiss it after council or local board member hired the lawyer, after all of that stuff. But there doesn't seem to be in Toronto, and again, other jurisdictions, a process to basically to deformalize it before it gets formalized. And we're trying to think through that. But I just put the footnote in is that Bill 9 will also not only create a universal code of conduct, but also a universal code of procedure. So I have no idea what Bill 9 will impose upon us when we start the investigation. My two pet peeves is one is that we have very limited, no matter what we find in our reports and after investigation, basically we recommend a reprimand or some kind of penalty with respect to pay if it's a counselor. But for local board members, which for me it's over 900, it's only a reprimand because they don't get paid. And I find that very frustrating. I don't see why I couldn't recommend mandatory training, sensitivity training, management training, governance training for business improvement areas. Here's people that may or may not have experience in running a meeting. Can I impose a penalty saying, look, I know you kind of made a mistake, but let's learn through it, and I'm going to send you a mentor for board meetings to run them properly and all that kind of stuff. I don't have that power. And even though in some of my reports I actually do state that, it's not a recommendation. It's just simply my word saying here would be a good idea to do that. The other thing, which I know some don't agree with me, but if we're going to have a universal code of conduct, one code of conduct, I think there should be mandatory reporting of all reports to council by integrity commissioners throughout the province. Because if there is an issue like decorum, and it's that word's in every single code of conduct in all 404 municipalities, I like to know how my colleagues are interpreting that. And I think to be fair to the councillors and those subject to that code of conduct, that interpretation should be more or less consistent. I'm not saying it has to be perfectly consistent, but there should be some rationale of how that's interpreted. And we won't know that because the committee said, no, we will not have any database for integrity commission reports. I don't get it. I think it should be required, but I lost that argument.
And I'll just jump in with a little bit of my pet peeve. I have a couple. I have lots, but I'll just focus on two. Looking at Bill 9 and training, I think there is almost a vote of non-confidence with respect to integrity commissioners in the proposal that integrity commissioners will have training by the provincial integrity commissioner, who better than local integrity commissioners knows what we do and how it should be strengthened. And then the mandatory requirement to train members of council and local boards. As Paul has pointed out, he has 80 85, with thousands, maybe, Paul, of individuals that you would have to train. And as we look at the proposed bill, where is the funding? Where is the resource for this? And currently, with most of the municipalities that I represent, training is not a priority. And the first question that I get with some of the smaller municipalities, with all due respect, is we don't have the money to have you come and train us. So the role of integrity commissioners in some of the municipalities is reduced to coming out when there is a code of conduct complaint and doing an investigation. Otherwise, sort of training and working on best practices, election FAQs, and social media use is seen as an add-on and would just raise the billing cost up. The other pet peeve that I have is penalty shopping. What has become more and more prevalent is when I conclude a code of conduct investigation, make findings that there has been a breach, and make recommendations to council. Of course, council is reticent to receive those, especially when it involves a suspension of pay for a period of time. And what I'm beginning to see, and which is cause for concern, is, well, that integrity commissioner over there with a similar circumstance actually only gave 1 week. And so why on earth are you suggesting a suspension of pay for 30 days? The integrity commissioner role is to be independent, is to be professional. We are all appointed based on our expertise, and therefore the reason will be found in the report that we have very conscientiously worked on and given our reasons. Each situation is different, and I think that training has to be a priority, training as to why we have codes of conduct, what those rules entail, and what might happen in those training sessions is a discussion. I agree with you, Paul, on what is decorum and what is intimidation. And here's what these integrity commissioners have said. So I believe we have, starting off with what John said, we have the tools to have an effective regime. And instead of strengthening them, as Paul has pointed out, we are eroding them. And I will just end by saying that this freedom of expression, when we have individuals who have very strong positions on encampments and story time in libraries, and I just feel that in the Pickering JR sustaining the position and the reasons of principles integrity, the court said very clearly, you do not have any impediment to freely expressing yourself. It's how you express it. And I think that the integrity commissioner, principles integrity, said that, voicing the concerns of your constituents is fine, but would you voice the concerns of your constituents if they were espousing, anti-Semitism or racism? So there has to be a parameter around which the regulation is to ensure the best interests of the public. So those are my pet peeves, and I could go on, but I won't.
Great, thanks. Ian, I wonder if you would take over the question and answer period. And
yes, I would ask people to click on React at the bottom of the Zoom page and raise your hand if you want a question. I have to go back and forth between two screens, so I'll do my best to look at the hands. But the first hand that has come up is from Jeffrey Abrams. Go ahead, Jeffrey.
Good afternoon, and thank you for holding this today. And I'm going to cheat a little bit. My question is, can I share a pet peeve? And I think it's important, given the discussion, the prominence of Bill 9 that shapes our discussions. And my peeve is that there has really been no engagement with the people that practice in the field, who have pragmatic things to say. There's really been no effective, real engagement or consultation on what might be done to improve the situation. Paul and John and Suzanne were all part of MECO's development of a submission to the province. It was about 20 pages long because it included the consultation document MECO provided in 2021. We've made attempts, and I will say that there has been no reach out for meaningful discussions from the province, from the Integrity Commissioner of Ontario, I'll say the media, and I'll even include academia, because this is one of the few forums. I congratulate you. This has been one of the few occasions when integrity commissioners have had the ability to discuss what might be done to improve the situation. As John and Paul know, we had 7 minutes to present to the committee on Bill 9, and there has been very, very little opportunity. The four of us here, and I see Harold's on screen as well, and there may be others, we may disagree with some of the solutions. Absolutely. But I'll tell you, just borrowing from the importance of municipal government, where good things happen, where deliberation is allowed to occur, there has been none of that. And so Bill 9, I'd have to agree, is more or less performative. It isn't designed to effect any kind of solution. That's my peeve. Thank you.
Do any of our panelists have any comments on that?
If I could, oh, Suzanne, go ahead.
Oh, thank you. I completely agree with Jeff, and Jeff knows the history of the Municipal Integrity Commissioners of Ontario, and there is clearly an intentional omission in speaking with this group of professionals that could very ably provide best practices and information to guide any sort of change to the legislation. I feel that the comments that Paul made about Alberta are a cautionary tale, but it is also probably a roadmap. Where the Minister of Municipal Affairs said very clearly that codes of conduct are only used to silence. And the four of us and others who are integrity commissioners know that's definitely not the case, and the courts have sustained that is definitely not the case. And in 2021, as Jeff pointed out, MECO provided advice. I believe that Greg Levine in the past also provided recommendations to strengthen the accountability framework. And so, yes, I agree with Jeff 100%. And the question then becomes, what next?
John?
Thank you, Ian. I was going to say exactly what Suzanne said, but probably less eloquently. I agree with Jeff. In fact, one of my comments to the standing committee was just that. I said, I don't understand how this government is putting things together. When it was looking at reworking the accountability framework for school boards, it consulted with municipal integrity commissioners. Heck, I remember giving at least 2.5 hours to the policy people at the Ministry of Education who were quite happy to talk to me. They had great questions, wanted to hear my insights. None of that has happened, and I've heard from my fellow colleagues that hasn't happened with municipal integrity commissioners from the Ministry of Municipal Affairs, which is just completely baffling. I don't understand how this government and I'm sorry, I'm upset at the government because it's the current conservative government that's bringing this forward. And my issue is it sucks and blows at the same time. Here's one other quick example. You need in this Bill 9 unanimous council consent or agreement to remove someone from office. And yet, this is the same government that has put forward strong mayor powers where it is the mayor, the one person who has to solve the logjam of the impasse of that municipal council's cost. Those are the words from former Minister Stephen Clark at the second reading version of the Strong Mayors Municipality legislation. So why, for these important decisions, and they're much broader than just the provincial priorities, do you have a strong mayor model where it's just one person making decision? But on the other hand, on matters dealing with conduct, you need a unanimous council. There's just a misalignment of what this government is thinking and how it's proceeding forward. Thank you.
Yeah, I just want to read the support for Jeff's comment. And just one little story. So we complained also about the lack of consultation because the Bill 9 amends both the Municipal Act and the City of Toronto Act 2006. And the minister said, well, look at the association, AMO, the Association of Municipalities of Ontario, was consulted. And on the one point about do you need unanimous consent to remove a councillor, they said, well, they support that. And during the committee hearing, AMO then sent a letter and says, no, that's too stringent. It's 2/3 majority. That would be sufficient. That wasn't accepted. So you can't say, yes, we consult through AMO and then don't accept the recommendations at a vote at committee. It just seems to me that shows that the there really wasn't a sincere effort to consult and listen. So and I just anyone interested in the process can read some of the opposition members' dissatisfaction with the process. So it's not my words, it's their views. They just thought usually in the legislative process at committee level, there's a give and take. And a number of the opposition members said there was no give and take. It was all give, no get take it whatsoever. So I'll just leave it at that.
Any other comments about Jeffrey Abrams' intervention? Suzanne.
Thank you. I unfortunately am looking for the way to raise my hand, and of course I can't find it, so I'm doing it old school. Thank you very much, Ian. I think what was a missed opportunity. We see that one of the drivers of Bill 9 is to the ability to remove elected officials from office if they are found to have egregiously committed acts that endanger someone's health or safety or what have you. And the province didn't have to look too far for models. I mean, as Jeff has pointed out, the submission was made that gave recommendations that were some very novel, but others were there. And if we look back to August 2022, MPP Stephen Blaise introduced a private member's bill, Bill 5, stopping harassment and abuse by local leaders, which was initially tabled during the previous provincial government, and this was carried to third reading. And Bill 5 had a model. It was that in situations where an integrity commissioner has found that a member of council has egregiously breached the code, misconduct, respect in the workplace, sexual harassment, that there would be a process similar to what we have in place for Municipal Conflict of Interest Act breaches, where the integrity commissioner would then make application to the courts. So for those who have such little faith in integrity commissioners, there was a work through. There was an ability to say, well, that's fine. We will have the courts determine, just as we have for years, whether or not there has been a breach. So I think, as Jeff has pointed out, the lack of consultation with people who do this day to day seems so very intentional. Thank you.
Thank you very much. I see a comment from someone that on Bill 9, did the Ford government waste everybody's time? It's on TVO today. Are there any other interventions at this point? And until you put your hands up, I have a question. Can any of the municipal integrity commissioners require a personal meeting with one of the councillors in order to settle something before it gets out of hand?
If I could, I'll try to. I'll give you my perspective on this. Now, I heard what Paul said before, and I was a little surprised, Paul. I haven't looked at your code all that closely recently. In our codes, we have a complaint protocol that we draft that actually has an informal process that someone could pursue, but that's. You could pursue that. It's not a precondition to doing a formal complaint process, but it's an informal process. And the way we draft it is if both parties, or if the multiple parties all agree, the integrity commissioner may be involved, but we don't make it mandatory that the integrity commissioner has to be involved. I've been asked many times, let's make that mandatory, that we have to have some sort of mediation or facilitation. And I'll tell you my perspective, and Paul, I'd love to hear what you say, because I've been against that. I think that's a bad thing to make it mandatory, because my efforts, and maybe I'm not as good as you or Suzanne or Jeff in dealing with it, but my efforts to try to mediate or facilitate always seem to end in failure. I find parties get very much entrenched in their positions, and because personal integrity is questioned, there's accusations back and forth, and in fact it seems to raise up the temperature as opposing to de-escalating it and coming to a place where someone might go, okay, I might want to apologize or something. Now, I have had those conversations. It's interesting. Very recently, I had one on a very contentious matter that we were dealing with, and I sort of just put it forward to the council member because the council member wanted to speak to me. So I spoke to them, and the council member said, what do you think if I apologize? And I didn't want to be sucked into that. And I go, how do you feel about apologizing? He said, no way, no how. Interestingly enough, when we went to council with our report, we were castigated for not requiring some sort of apology. And I knew full well why we didn't do that. But anyway, but to go back to your point, we have informal processes that are set out. I don't like having some sort of mandatory mediation, facilitation, consultation built in, but I am okay to do it if the parties both ask.
Thank you.
I just to go to the exact question, I don't think I could compel outside of a notice of investigation to meet with anyone. But it goes back to John's point. I don't think mandatory mediation or mandatory facilitation works either. It's just in those cases where you think, and the issue with, we do have an informal complaint process, but as you said, John, all parties have to agree.
Right.
And I have gone to the situation where I've approached the complaint and says, do you think we can resolve this informally? And in most of the cases, it's not a big deal. We sit down with the counselor or the board member and we resolve it. And it really works better at local board members where they have to get along at some point, right? You're a member of the board, someone said something that wasn't appropriate, and rather than going through an investigation, we just have a meeting with the consent and we resolve it. But I agree, John, a mandatory mediation is problematic. I totally agree.
And I'll just add in response to the question, like John's codes of conduct for the municipalities where he's IC, there is in the codes of conduct for which I am IC in municipalities, there's obstruction. So if I have a formal code complaint investigation and I would like to meet with the respondent, and they say, no, thank you, I've said what I have to say, I certainly could bring a report to council advising that the party is attempting to obstruct the investigation. What I do, and I get back to training and why it's so very important to the very structure of an accountability regime, where I'm allowed, and I say that tongue in cheek, to give training to council at the beginning of term, I stress the importance and the role of the integrity commissioner and that the code is theirs. It's not me telling them what to do. It's not my moral compass guiding them. It's them saying that this is important to us. And that's why with 444 municipalities, you can't have one code, because while honesty is important to everyone, there are other focuses for other municipalities. And so I say, with training, you understand that when I call you or email you for whatever reason, it's not because I've got nothing better to do or want to bill you. I don't say it that way, obviously. And so it's important to recognize that there is a role of the Office of the Integrity Commissioner. And in those instances where I have been allowed, I find that there is more acceptance of, responding to my call.
Thank you. And I see Jeffrey Abrams' hand up again.
Just try to stop me. Um, there's commentary about this anticipated universal code, and I'm really just reflecting upon what the MECO document said. I wanted to make the point that um, to the extent that there are deficiencies across the board in codes of conduct, the province could impose that they be included in codes tomorrow by regulation. Don't need a statute in order to do that. On the question of whether there ought to be a universal code, and we certainly heard Paul's remarks, and I agree with them. But I step back and I think, in those municipalities that really sparked the need for something like a Bill 9 or Blaze's private members bill, it wasn't the code of conduct that was the problem. Those codes were fine. There's no magic necessarily in a code of conduct on the ink on a page. In fact, most codes say and do the same things in different ways. Some are better, some are worse, sure. Some are better guides, some are poorer, some are more stringent, some are more value-based. You can have that conversation. But it isn't the code itself that is the problem. In fact, my view of it is you ought not to impose a code, certainly minimum conditions, sure, but it should be the responsibility of a council to look at the darn thing every year and maybe to tinker with it and to take it off the shelf so it's a living document, so it's real, and that it flows into the most important function of an integrity commission. You've heard it from the panelists today. It's not complaint investigation. It's the preventative stuff that occurs through education and the giving of advice. So blending the value of code, discussions on the code, attaching it to the circumstances of the day in different municipalities, and enabling, facilitating training and advice giving is probably the best way to go here.
Yeah, those are very good points. And I see my friend Robert Shepard has his hand up. Go ahead, Robert.
Yeah, thanks so much, Ian. Thanks to the whole panel for hosting this. This is absolutely wonderful to have this conversation. I think I'm going to ask a similar question that Jeff just posed, or make some similar comments. And I'm thinking back to what even promulgated a piece of legislation like Bill 9. And it seems to me that if you read through the media and take from that what you will, much of the concern was about rogue, in many ways, integrity commissioners making
Robert, I think there's a problem with your audio.
provide. Can you hear me now?
Yes.
Okay, good. So I'm not to repeat all of that, just to say that the province seems to be reacting in some ways to public comments that integrity commissioners are acting in the Wild West. I remember that comment being made in the media, and they think that, okay, we need to bring some consistency and coherence to the integrity field in Ontario. That, in addition to reports within even the integrity field, where some integrity commissioners are responding in negative ways to other integrity commissioner reports. So there is, from the provincial standpoint, we're seeing reactions that are quite negative within city councils, and then we're seeing integrity commissioners in essence fighting amongst themselves. So I guess my question to the panel is there a rationale for even having a standardized system that is provincially operated in some way? And the second question to that would be, does it look like the current bill, or does it look like something else? So in other words, what are you rationalizing at the center. And is there a rationale for integrity commissioners to operate within their own city council mandate? So either a centralized system or a decentralized system. What are your thoughts?
Thanks very much, Rob. Who would like to take the first stab at answering him?
I'm gonna start.
Okay.
I'll let my colleagues follow. So the Wild West. I would submit that in every area of expertise, there are those who go off the rails. I'm not going to deny that. But it begs the question, if the concern was that there are some amongst you who are not following the rules, then why not discuss with those who are part of that group exactly what we're doing here today? What works? What doesn't work? How has it been working? Here are thoughts, as opposed to saying, because of my perception of 2 or 3 or 4 bad apples, we're going to take it over. It just seems like a very heavy-handed way of dealing with an issue that I agree, Robert, is a concern. If we are dealing with public interest and the perception of the public, then the people who are tasked with reviewing the conduct of the elected officials better be stellar. The second piece is integrity commissioners fighting amongst themselves. Years ago, and I know that John and Jeff and I believe Greg was there also. I remember Jeff Abrams actually at the City of Toronto was tasked with, we were putting all the thoughts and criteria of what the standard should be that we as integrity commissioners would hold ourselves to. We were looking for sort of an explanation of the criteria that an integrity commissioner should have. And so again, without involving those who are and imposing that which you know nothing about makes no sense. So I think both with respect to rogue integrity commissioners and with respect to some members of council, some members of the integrity commissioner group calling out others without standards, that's quite easy. Well, I think that integrity commissioner shows a lack of this, that, and the other. Well, we don't have standards, and many of the integrity commissioners are members of the Law Society. I'm not a member of the Law Society, and so some of the members of this group say, well, here are our professional responsibilities and discipline. How come that's not the case over here with integrity commissioners? Again, let's have a conversation as opposed to let's wipe it out.
Thank you.
I think it's a good question, and I don't have a good response, except that the former Provincial Integrity Commissioner David Waite did a report in September 2024, and in his report he put sort of the indices or a checklist of what he calls effective municipal framework, and it has a whole list of things that should be included. I think Bill 9 would have been better served by creating that checklist, and those municipalities which didn't have all those precautions and processes could be raised up to some common uniform level, rather than imposing down a uniform process that actually will lower the protections and safeguards and procedures. In other words, is that rather than raising the bottom, we're shrinking the ceiling. And so I think that his report, you may disagree with some of the components, but it would have been a great forum for discussion as a starting point among the stakeholders. And I think that's one of the universal comments you're hearing, is that the stakeholders, municipal councilors, integrity commissioners, experts in the field, academics, did not have the ability to sit around a table and actually have the kind of discussion we're having today. And I think Bill 9's the worst for it.
Thank you. John, do you have any comments? Your audio is off.
I'm sorry. No, I actually don't have really anything more to add because I agree totally with what Paul and Suzanne have said, and what Robert was actually starting to ask before he say before he asked the question. So I'm fine with that.
Thank you very much. Greg, do you have any comments?
Sorry. Yes. Probably too many, but um, I'd like to just address the reticence of council and the what to do about the change that has been perceived in how council reacts to commissioner reports and the badge of honor of having a negative report and all of that. Do you see the resolution to that as giving the commissioners more power? Should the commissioners have order power? Some municipalities do that.
Yeah.
Is that the answer? And doesn't it actually raise the question of the potential for centralization? If you look at one other model is the Quebec model,
Yeah.
which they've created an arm of the municipal commission, which is a municipal ethics commission. So it's a provincial entity which hears complaints about the codes and deals with them. And it has more power. Is that sort of the route to go? Because the model was started in Ontario as a kind of specialty ombudsman model. And it was based on the faith that councils would be rational, that they would take responsibility, that they would act appropriately when their commissioner reported to. But if we see that not happening, what's the rational response? So I just put that to all of you.
So if I'll just jump in some instances, Greg, I would agree that it might be appropriate to vest or delegate to the integrity commissioner. But even though I am really disappointed with how the system has played out, I still believe that it is the council itself that really needs to respect the system that it was created from and that it serves in, and should hold its own members to account. So, however, many councils have shown, and I can't believe how many councils I've gone to, where the councils are going, well, I don't know, why is this put in front of me? Why do I have to be the judge of my fellow council member? And they're almost, and they want to abstain. Now they know cleverly that if they abstain, their vote goes to the negative, so they can say they abstain and yet get off scot-free to get their buddy off. So I've seen that happen. So in those instances, I would say, you know what? It really should go to the integrity commissioner, who's the actual investigator and adjudicator. But in most instances, I really do think our job is to be investigators, advice givers, and educators, not to make the adjudicative decisions on what penalty is to be imposed, as opposed to what penalty or what remedial measures should be imposed.
Thanks. Other thoughts? Thanks.
I will jump in. I have a radical thought here. I know that members of council will, and I say this with all due respect, if I sound as though I'm being disrespectful, it is not my intent. Members of council are elected and they come with their families, and some of them with extended families, with overjoyed that they've been elected to office. And as they swear their oath of office that they will not put their own private interests before others, that's the core of who they are supposed to become. And so that's wonderful. And what has the overall Ontario government said? They've said, hey, here's what we're going to do. Where there is a breach, and you know what, integrity commissioners, we're going to give that opportunity to you. So ratepayer, you go straight to the courts, or here, you can also go to the integrity commissioner. However you do it, it's going to be the courts, because We believe that the courts are so vested with that level of detachment that they are going to decide if there has been a breach of that very important oath of office that you took when you were elected. So how come harassing is not held to the same standard? How come those four itty bitty regs that we have right now cannot be seen as egregious and important enough that in those areas, not the whole kit and caboodle of the code, but in those areas, there will be a carve out that the integrity commissioner will follow the same model. So I don't know that I have the solution, but I do think that one option may be for egregious where you put the safety and health of an individual, especially staff, where there is an MCIA breach and others, as we see, using the property of the municipality in those areas, model very similar to MCIA. That is an option. It's been tested, and it's something that can be done.
It's a great question, and I don't have a great answer, except our municipality is over 2 million people. If you upload the function to a provincial entity, I'm struggling to try to get my responses in a timely way. I can just imagine how long it would take for a municipal or for a provincial entity. But I also like the notion that I'm accountable too to the residents of the city of Toronto. And I think that local connection, good or bad, is good. I'm accountable to city council. And ultimately it's up to city council to decide how to moderate their own behavior and conduct, because I just make recommendations. So I'm always leery of uploading things for that kind of stuff, both practically and theoretically. I think local accountability for local politicians is a good thing.
Sure. Thanks.
I see your hand up again, Jeffrey.
Yes, as the self-appointed honorary member of this panel, let me weigh in on that. And there are a number of good reasons why I think integrity commissioners should not be making the decisions. We don't have time to go into that. But I think, the original legislation, perhaps not on purpose, but the province got it right because it created this right-sized process for municipalities. It's not a tribunal. It's not a replication, it ought not to be at least a replication of the court system or litigation. Integrity commissioners should have the ability to, I'll use the word settle, to resolve things even in the midst of a complaint investigation. That serves the municipal client well. With all that said, when we do report, we've all had the experience of councils not doing a good job of acting in a disciplinary mode. They don't get it. And I get why it's hard for them. Now, there has been disagreement even amongst the people with microphones today about whether the MECO proposal is a good one, which is to create a review panel. Let's at least talk about something like that. So it's not the council that's making the decision. It was still a body of peers, but some other organization. That, I think, is a starting point for a conversation on how to remedy this particular issue. It may not be the end point, but it's a starting point. And I would eschew anything that replicates other forms of litigious advocacy, adversarial processes, because I don't think they serve municipalities at large at all.
Does anyone else have any comments or questions? If not, I'll just make one before I turn it over to you, Greg, to thank our panel. Years ago, a former City of Toronto Integrity Commissioner, Janet Liepert, was a guest at one of my graduate classes. And as you may remember, there was a fair amount of friction between her and Rob Ford. And so one of my students asked, well, how did you handle those issues with Rob Ford? And her answer was simply, you got to love him. Treat him with respect. Always greet him with a smile. Make him feel like a human being. and she said by the time she finished her role, that she felt that Rob Ford had really understood what a conflict of interest was. So I found that a very interesting answer, as did my students. So I'll turn it over to you, Greg.
Yeah, thanks. Interesting story. Well, many thanks to the panel. Thank you all. This was a really, really great discussion. Appreciate your taking the time to speak with us and to answer questions. Thanks very much.
Okay.
Thank you.
Thank you very
Thanks,
much, Greg, and
everyone,
thank you
for
for the
attending.
privileging.
If you'd
Thank you,
like to get
everybody.
on our list of panelists, future panels for the York Collegium for Public Ethics, please send me an email. I'll put you on our list. My email address is igreene@yorku.ca, and I'll put you on our list. Thank you very much, everyone.
Thank you.
Thanks.
Thank you. Bye-bye, everyone.
Bye.
Bye-bye.
Bye-bye.